The Honorable Justice E.F. Ikpomwen was born in Warri, Edo State, and graduated from University of Nigeria, Enugu campus in June 1978. After she was called to the bar as a solicitor and advocate, she did NYC and worked in Ministry of Justice, Edo State, Edo State, as a counsel and rose to the position of Principal State Counsel before transferring her service to Edo State. In January 1992, on her elevation to the High Court bench as a judge in the year 1999. She was appointed as pioneer anti-corruption judge for Edo State in 2002, and in 2017, she was appointed the Honorable Chief Judge of Edo State, but she retired in the year 2019. In the course of her service, she attended many seminars and courses and received many awards. She is a fellow of Commonwealth Judicial Education Institute, fellow Nigerian Institute of Chartered Administrators, fellow Institute of Chartered Mediators and Conciliators, a Polaris Fellow, the first Benin female Chief Judge, first female President of Boy Scouts, Council of Edo State, recipient of Royal Beads from the Oval of Benin. She was given the chieftaincy title of Esohe F of Ebele Kingdom. His Lordship regularly gave public lecture of Honorable Justice Esohe F, Lord Lecture Theatre at Benson University, a member of Church of Christ of Latter-day Saints. She was honored by Boys Brigade Edo State in 2018 and was a patron. She's married and blessed with children. Permit me to call on the chairman of the NBA to formally ask us to come and in the
My Lord, Honorable Justice Esohe Francis Ikpomwen, immediate past Chief Judge of Edo State, members of the High Table here, I want to join the organizers of this event to also welcome us to this historic event. I've just been asked to welcome my Lord and to ensure that, of course, my Lord is ushered to present the keynote address. And I know that considering the pedigree of my Lord and the very rich biography that has been ably presented to us, my Lord will do justice to this topic, this keynote address. My Lord, may I seek your leave to invite you to do the needful. Thank you, my Lord.
The chairman of the bar, Mr. President, I guess you're the director of the Freedom of Information Council, and your members here present, Mr. Osakwe, Honorable Osakwe. I've known him for years, always in court, fighting for the downtrodden, and the other participants here. Sorry, I didn't quite get your name. Ladies and gentlemen, my keynote address. I'm delighted to be asked to give the keynote address on this occasion, commemorating Open Data Day. The theme for this day, Open Justice System, is quite topical and relevant at this time when most work is done virtually and by information communication technology, ICT, whereby information production are stored, processed, transmitted, converted, and duplicated through electronic textbooks, instrumental software, email, chat, and distance learning. Justice system is about frontline delivery. And the question arising just now is how open is the system? There is no doubt that the administration of justice in Nigeria urgently craves for serious reforms in order to match the challenges that have arisen with globalization and the changes in the society where criminals have become smarter with technology. This is per Dr. Bukola Saraki on the 10th of August 2017. One of such reforms in the justice system recently is the Administration of Criminal Justice Act. However, practitioners are aware of the problems associated with implementation of the said act. The concept of open justice requires not only transparency, but openness of all legal processes. I must quickly state here that as far as I can recollect, the administration of justice in Nigeria takes place in the open court, accessible to all and not in secret. This is a fundamental rule of the common law. By extension, open justice applies the principle of open government that has the hallmark of transparency, civic participation, and public accountability. There is no gainsaying that in our country today, open government is not practiced, and little wonder the effect on the justice system is reflected. Anyone or institution that truly wants to strengthen democratic institutions must work for the implementation of an open data policy and accountability. It is imperative for courts of law to hold sittings in public. Not only should proceedings be conducted in the open, evidence presented in court is communicated publicly to those present in court, making sure fair and accurate reports of judicial proceedings by persons or the media be open. However, the principle of open justice is not absolute, as there are some proceedings conducted in camera. The courts may order certain information concealed from the public. Some persons may be identified by pseudonyms. Suppression orders made to prevent prejudice to the proper administration of justice, to advance security of state, to protect the safety of persons, and prevent undue distress and embarrassment to a person in cases involving sexual/indecency offenses. To facilitate open justice, it is imperative that courts employ open data. Now, the concept of open data is whether data is made freely available to everyone to use and republish without restrictions from copyright, patents, or other mechanisms. Open data will aid transparency and accountability in the justice sector. The court system ought to benefit immensely from open data, as this gives rise to open knowledge. Information should be available and accessible generally. The Federal Ministry of Justice in 2017 published the National Policy on Justice, where at pages 38 to 44 in theme 10, with subtitle, quote, Openness, Transparency, and Accountability, the policymakers showed an awareness of the need for openness, transparency, and accountability in the justice sector, and acknowledged the constraints. At page 41, it is stated thus, and I quote, there is a dearth of routine data and statistics to enable proper assessment of the performance of justice sector/institutions. That generally there is a resistance to ICT innovation by officials of the sector, which may be deliberately aimed at concealing wrongdoing and inefficiencies. The justice sector currently lacks the infrastructure to support digital or automated collection and management of information to protect its integrity and facilitate its timely retrieval. Still quoting, most justice institutions still rely on manual methods of data. Then by me, Courts still have to manually record processes, even in this era of technology. And management are vulnerable to the phenomenon of missing file. At page 38, it goes on to further acknowledge that, quote, both internal and external transparency and accountability mechanisms for justice sector institutions have been notably weak. Compliance with Freedom of Information Act by justice sector institutions has been poor. There is low awareness of the provisions of the Act among the public, who are not well informed of the type of information they are legally entitled to demand from the public authorities, including justice sector institutions. End of quote. And I quote again, there is inadequate knowledge by government institutions and public officials of their duties under the Act and poor implementation skills. The effectiveness of the Act is further undermined by the absence of similar legislation at the state level. Then my contribution here is that I personally do not agree that there has to be a similar legislation because of the doctrine of covering the field. Once the federal government has enacted an act, it's for the entire country, and we do not need to pass another law at the state level on that subject matter, because this field has been adequately covered. And it goes on to say that there is confusion over the impact of the Act on the scope of Official Secrets Act. In place is still the Official Secrets Act. End of quote. It is evident from the National Policy on Justice 2017 that the needs are well known. That is, for proper data, openness, etc. So also the challenges which are well articulated in the said policy, as funding for courts, infrastructure and facilities, upgrading staff skills. It is also stated that, I quote, without strong institutional capacity, backed by effective legal frameworks, commensurate infrastructure and facilities, working tools and equipments, and skilled, well-motivated personnel, the justice sector will not be able to deliver on the numerous roles and mandates that are assigned to it by the law. Capacity strengthening of the institutions in the justice sector is therefore essential to promoting access to justice, independence of the judiciary, coordination and cooperation across the justice sector, as well as improving public perception and confidence, as currently many of the institutions of the sector are severely challenged in terms of capacity to deliver effective and efficient justice services for the benefit of the people of this country. End of quotation. I have endeavored to quote extensively from the National Policy on Justice, so I am not accused of running down the sector. It is crystal clear that so long as the judiciary in the justice sector depends on the executive for funds, it cannot foot the wage bill for openness in all ramifications. As to ensure the digitalization of all processes used in court, there has to be a huge budgetary provision which is subject to the determination and consideration of the executive. Still quoting from page 46, which states, I quote, in most instances, these issues are related to the limited allocation of funds to the justice sector in the budget and non-release of the allocated funds. End of quote. In conclusion, it is my observation that generally there is a good measure of openness in the justice sector, in that, to the best of my knowledge, from time immemorial, when any information is required from the courts by application and necessary fees paid, it is usually provided. Judgments and rulings in courts are readily available. I recall a case where a chief magistrate was disciplined for unduly withholding a judgment during my tenure. Comparatively, efforts are now being made within limited resources to use ICT to get information out in the public. I would add that the independence of the judiciary will go a long way to achieving open justice. There is also, in my respective view, the need for publicity and enlightenment of both the civil society and the public officers on the need to have open data and for open justice to thrive. It is my hope that in the very near future, we shall truly have an open justice system using open data for our courts proceedings to be subjected to public and professional scrutiny. Above all, I pray for that day when we mark the financial autonomy for the judiciary.